I mean, Osei Boateng's family has not raised any issue about the fact that Abia and I'm sure we all like the song. But the point is that at any point in time you want to touch on somebody's work, our laws require that you seek consent from the individual. Hi guys, welcome to BTM Afrika. NY DJ here. I'm pretty sure you are wondering why I'm smiling all of a sudden. You say, "Who be a market cancer?" Now you take it this particular shot, so that you'll be surprised. But welcome to BTM Afrika. This is the channel where we share all the insightful conversations with our guests, and of course, I do editorials where I get to share a bit of the law with our very viewers who are always watching us. So thank you very much for tuning in, and please do remember to subscribe to the channel. Leave your comments. If there is anything you want us to address, we will definitely address them either in the comment section or in our next video. Now, if you follow Ghana's showbiz, you realize that for the past 1 week and a couple of days now, the very conversation that's been going on has to do with alleged copyright infringement and all that, from radio stations to TV stations. Everybody is talking about it. People have spoken with emotions because they are related to certain fashions of the whole issue. So, being so kasa with emotions, people are not really paying attention to what the facts are. But on this channel, we are going to give you what the facts are, and of course, we are going to share with you what the law is saying. Is saying, because if you should go to court, then Beka. That's what we are going to look at here on BTM Afrika. So, welcome to the show, and please make sure that you are subscribing, because that is very necessary. All right, so let's get into the details. One of the very topical issues that's been going on has to do with copyright issues. Copyright issues, though, who are the parties involved? It has to do with the family of the late Osei Boateng and then gospel musician Adom Kiki. Now, the conversation has been that, Adom Kiki akwako ria Osei Boateng nyom credit, and he's making money off it, as he is profiting off the music, he's performing it without consent from the family and the right estate. There's been conversations about that, and this actually sparked up because Adom Kiki actually granted an interview on Peace FM with Michael Ola. During a portion of the interview actually came out, as in a snippet of the interview came out. And I said, boss, and he said, I think that portion is what has actually generated all this conversation.
Gyatabruwaa bedinia na so nepa biara hia.
It's when I was no. Oh, I love you, my brother.
For me, I believe that address issues we need to look at the issues holistically and not just pick portions of certain interviews and then drag or draw conclusions. The very reasons why our confusions and answer a friend BB dispute because there are people who are selective. They select a portion of the whole thing and make a whole news out of it. But the question is, did Adom Kiki really say yes on the boss? Let me create a scenario for you and what exactly happened in the studios of Peace FM. So, that typically as an artist, if you are going for an interview, it's quite normal that the presenter or the DJ will play a song that you've done. So, imagine I come into your studio and then I've done a cover version of a song. And then once I get into the studio, it is played and the guest asks me, my response will be Annie. Do you get it? My response definitely will be Annie. And in that situation, it does not mean that I do not know, say somebody did the song, because in that same interview, Adom Kiki had actually acknowledged, the original composer of the song is Osei Boateng. So I think this whole brouhaha about the fact that he says on the board, is a non-starter in the first place. Because if you're asking yourself, Obi and Compass Obama credit, and right from the beginning of the video, you know what it takes to actually shoot a video and give credit in the video and get it on the distribution platforms, and call money credit in that video already. Again, if you check on social media, you see the time that Joe Metal actually posted the video. He posted and says a rating by Osei Boateng. So they've always given credit. If you check on the metadata for all the other distribution platforms, it is there. I've seen people share screenshots of something on YouTube and says that he didn't give credit on YouTube. If you pay attention, Adom Kiki doesn't even have the video officially on his personal channel. But it is Adom Kiki topic. That's where you find the video. And if you know about music distribution, you know about YouTube and all that. When they say topic, It means they are just putting content of the person together and then showing that to you. So it's not like it's officially on his channel and didn't give credit, because I think if he didn't want to give credit, he wouldn't have even added that credit back at the end of the video. I mean, enough of that. Let's put that aside. So the family of the late Osei Boateng have actually released a statement. According to their statement, Adom Kiki did not seek any consent from them, but Adom Kiki says he has a cover license. That one too, they say, where did he get the cover license from? Because you've not spoken to us. You've not approached us. So how did he get the cover license from us? Again, you are saying, which that one, I think we all know that Adom Kiki has never said that. But let's get into what the law says. People are asking, does a cover license absolve Adom Kiki from any litigation and any form of infringement? Did he need to seek consent from the family? If you follow me on Facebook, you might have seen, say, I've written something about, this whole copyright thing and what needs to be done and what a cover license can actually guarantee you and all that. But first and foremost, we break it down. We say copyright cry and materials bang and amrabo home buying. Let me take you to your Copyright Act, Act 690, and let's get into works are emrabo home buying in Ghana. Now, work eligible for copyright. An author, co-author or joint author of any of the following works is entitled to the copyright and protection afforded to that work under this act. 1. Literary work. B. Artistic work. C. Musical work. D. Sound recording. E. Audiovisual work. E. Choreographic work. G. Derivative work. And H. Computer software or programs. So that tells you, say, these number of things, as in copyright. Naturally, once you actually put out a creative work, which is original, you are protected by the laws, but you are always advised, at least go ahead and register it with the copyright officers. All right, that gives you a stronger protection. But I mean, even if you don't go and register it, you are still protected under our laws. That's what the law says. So it means that if we are looking at compositions, we are looking at musical works, it means Osei Boateng works, they are protected under the laws of Ghana. So that is guaranteed, it is protected. Now, once you have the copyright to a material, what does that say? And now copyright now me also no. So far, so when they saying they now me copyright no. Let's break it down. Now, once you are the copyright owner of any content, there are some rights that you have in them. One of them is economic rights. The other is moral rights. Economic rights and moral rights. Now, let's get to Section 5 of the same act. That's Act 690, a copyright laws. It talks about economic rights of authors. Now, Section 5 of our act says that the author of a protected copyright has the exclusive economic right in respect of the work to do or authorize the following or any of the following. Pay attention. It says the author of a protected copyright has the exclusive economic right. Now, exclusive tells you that nobody has any other right in that material. Once he has the copyright protection on that, he has the exclusive right, meaning no other person can make or exploit it. Now, these are the things that only call economic rights in the song. A. The reproduction of the work in any manner or form. B. The translation, adaptation, arrangement, or any other transformation of the work. C. The public performance, broadcasting, or communication of the work to the public. D. The distribution to the public of originals or copies of the work by way of fair sales or any other fair transfer of ownership. And E. The commercial rental to the public of originals or copies of the works. So once you have the copyright to any material, these are some of the benefits and these are some of the rights you have to it. You have the exclusive rights to the material. Again, there's the moral rights. Now, the moral right says that in addition to the economic rights, that's Section 6, the author of protected copyright work has the sole moral right, that's to claim authorship of the work, and in particular to demand that the name or pseudonym of the author be mentioned when any of the acts referred to in Section 5 are done in relation to the work. And B, to object to and seek relief in connection with the distortion, mutilation, or any other modification of the work where the act would be or is prejudicial to the reputation of the author, or where the work is discredited by the act. So when Osei Boateng's family talks about giving credit, that is where the moral rights come in. Once you touch on somebody's work, you are required by law to give credit to the original author or the original composer, which obviously for me, I think our very own Adom Kiki did that in all the distribution platforms where you have the credit in the metadata that has been shared on social media and other places. So he actually did that. But the question is, did he seek the economic rights? That's the question. Did he seek the economic rights? And did he need to actually seek economic rights, especially when he was distributing it with DistroKid and he had actually gotten a cover license? Now, this is where it becomes a bit tricky, because people have said that, oh, once he has, the distribution license or he has the cover license, he's allowed to actually distribute the music on all those platforms, because at the end of the day, he's getting a certain portion of the royalties. The late Osei Boateng's family is also getting a certain portion of the royalties. But the point is, our laws tilt towards seeking direct consent from who the owner of the copyright is. That's why I told you when it comes to do with the Section 5, it says the author of a protected copyright work has the exclusive economic right in respect of the work to do or authorize any of the following. So if I have my work and you want to do anything to do with it, or you want to do anything with it, the most important thing is to seek direct consent from me. That's where the challenge is. That's where the challenge is. Our laws tilt towards seeking direct consent from whoever the copyright owner is. Once you decide to say, so I'm distributing it online, yes, I've done that through DistroKid, there's a cover license and all that. The cover license does not actually exonerate you and protect you from being sued by the original copyright owner. I've had conversations where people have said that, oh, but I mean, he's making money, he's allotted some percentage, all that and all that. The fact that you allot percentage and all that or royalty distribution per the law does not mean that you are absorbed from anything, because you still did not seek the consent of the person. You know what is interesting in this? I mean, Osei Boateng's family has not raised any issue about the fact that Abia and there now, baby. I'm sure we all like the song. The rendition or the cover, it's beautiful. We all like it. So I've not seen them raise any contention with that. But the point is that before you touch anybody's work, you need to seek consent from the person. That's why people are saying our laws are backwards, because I mean, we are in 2026. And at times you might not even know who the original composer is. How do you get in touch with the person? It becomes difficult and all that. But you see, say, oh, car. Now, sorry, no, my befa car, no, my car, no, my car, chose, Charlie, my cotton car, I mean, 100 cities into 30 cities. Would you be okay? You will never be okay. So our laws are saying that before you touch on anybody's work, seek direct consent from that individual, especially when it has to do with economic rights and moral rights. It's not enough to say, so me credit. No. And no credit there is a non-starter, because the moral right is there. The moral right is, you are still required by law to credit the person, say the person is the composer, or the person is the writer, or the person is whatever. But the economic rights is to the effect that the person has exclusive economic rights. The person or no pay and distribution platforms don't have any right over my work. The distribution platforms, they do not create content. The content does not belong to them. So they can't share a certain split for me. It is mine. So until I decide that I want you to work on it, you can't do that. So I think as industry, when these things come up, we need to sit back and really analyze all the things that are going, ask ourselves, say, what can we learn from this? Unfortunately, in our settings, most of the times when some of these, issues come up, because before you realize maybe the parties have sorted it out. So there's not enough, case law on some of these things. But at least we know of Rexoma, one company in the eastern region where he took them on, and he won some, he had some compensation on that. But the point is that copyright laws are so strict in our country, and that once you want to touch on somebody's work, the laws require that you seek direct consent from the individual. Now the point is, okay, now it's online, it's out there. We've done the distribution, we've done the split and all that. You are supposed to get a certain percentage. We are getting our own. What do we do now? Especially now that the copyright infringement is said to be there. What do we do? Our laws also make provision for how we can resolve disputes. As in when copyright issues, but how do we resolve it? And let me take you to section 48. Section 48 of our copyright laws. It talks about settlement of disputes. Okay, you also be a faminium where seeking consent from me. What do I do? These are measures are emeraldy at all, so you can actually follow to make sure that you get a resolution. 1. Where a dispute arises between any parties under this act or in relation to a copyright or claim under this act, the parties involved in the dispute may seek to negotiate a settlement of the dispute. So the parties may seek. Now the law says may, is not shall, because enye. So when he says the parties may, that's if the parties agree to have those conversations, then they can go about with that. I've heard somebody say they need to go strictly with this, and yes, the court and all that. I mean, the Courts Act also makes certain provisions, but this says that the parties may, okay, the parties may seek to negotiate a settlement of the dispute. 2, where negotiation under subsection 1, that's what I said. If it fails, a report may be made by either of both parties to the copyright administrator who shall mediate for a settlement. There are copyright offices across Ghana. In Kumasi, I know there's one at the High Court because I've been there a couple of times. So you can actually see that copyright administrator and talk to them about this copyright issues or whatever it is that's going on between the parties. And the copyright administrator may bring in and mediate so that both parties can agree on a settlement. 3, a party dissatisfied with the decision to submit to mediation made under subsection 2 may seek redress from a court of competent jurisdiction. So when you go through these processes, if both parties try to sit and talk about it, and both parties, any of the parties can decide to go to the Copyright Office and say that this is the situation, so let's have a resolution. Both parties can come in, the copyright administrator may try to mediate so that there will be a settlement. Now, if the mediation and then both parties and one party feels, no, I'm not excited about this, then the party can now go to court. So this is may. It means that you can decide to go to court direct without having to resort to these ones. But of course, let's not forget that our Court Act is also proving that, listen, you need to now pay attention to ADR. In Sembi or court in Sembi gune so do so dada. But in Sembi or na mo betimi atena se aka, the court will opt that monkoka than Zemo de Beba court. If mokoka ye mambo chance, monkoka na mokona asanye ADR, then you can bring it back to court. Obeka that the Lumba case now, a court, that's the High Court. Her Ladyship Dorinda actually asked the party, say, Omon China, Omonko Solve. I think she gave them like a week or something, but they brought it back to court. So that's what the copyright laws are saying. That is what the Court Act is also saying now, that they give you enough room. Say, if there's something that can actually be resolved, that parties should go and try and resolve it. If it doesn't work, then you come back to court. So at the moment, this is what the parties can do. The parties can decide to sit and have a conversation. If they agree to their own terms, that is fine. If they don't agree, one party can actually approach the Copyright Office and say, this is the situation. They can call for a mediation. If at the end of the day, and don't swan far, then whoever is not satisfied can now go to court and then sue. Now, when you sue, obviously you're going to file for a civil case. Well, if you sue, then there are damages. Now, some of the reliefs are the families can actually be seeking for in this particular case, especially if it is established that yes, indeed, a copyright infringement and now there's been a breach of the copyright infringement, then obviously there could be a number of reliefs. They could be seeking for the fact that, okay, there are two platforms in the delete from all the platforms. From you have to account and give it back to us. And then again, they can even sue for damages. Say, because of Adena, they can also sue you for a lawyer, fine, and they can sue you for all those things and prevent you from further using the song and even using any of their songs again. So these are other reliefs that they can seek. But I feel and I pray that we don't get there. I'm just hoping that both parties can actually have a sit-down conversation and settle this, because you see, from where we are getting to and in modern times, Distribution issues are different. Our laws, obviously, I feel akakakra, because there are certain things that are not covered, especially when we have the digital era. But the point is that at any point in time you want to touch on somebody's work, our laws require that you seek consent from the individual. If you seek consent and the person tells you, oh, try meba, and the person never returns or never replies you, you still don't have permission. Until the person permits you or allows you to have it done, you can't do it. Cover license, yes, is there for the distribution platforms, like I said. But the point is that distribution platforms, they do not own the content. And you're media. And you're going to me say, me product, and me property, no. Ye chem ni amami say, no. They can't do that. So I think we need to be learning about these. And I think it's good that some of these things come up so that we get to learn and we get to educate ourselves. So going forward, please, once you want to touch on somebody's work, just make sure that you are seeking direct consent from the individual. Often, it should be in writing so that if anything be this is my evidence, we saw consent, this was the split and all that. So we don't have to find ourselves in these times because, with times changing and development and all that, I think we need to be learning about some of these things so we avoid all these issues and all the brouhaha that's going around. So that's it for the Adom, Kiki, and then the family of the late Osei Boateng. I believe that the parties are having conversations so that they're able to sort some of these things out. At the end of the day, what is the point? The point is to let God's word or the message go, right? But in as much as you want to let the word go, it's important that the rights are respected. So this should be it. I'm pretty sure at least there's been some insight to this. Maybe there's a question you want to ask. You may drop that question in the comment section. I might respond to it directly myself. Or you may want us to touch on something different another time, which we will definitely look at. But I believe this has been insightful and you may want more. Thank you very much for watching. Please feel free to share and always make sure that you are here on BTM Africa. My name is NYDJ. Thank you for watching. Catch you some other time.